Hello and welcome to Courts This Week at LiveLaw. I am Taniya Pandey, taking you through important judgments of the week gone by. The Supreme Court has negated all objections and upheld the validity of e-voting process for winding up of 6 mutual fund schemes of Franklin Templeton. The court has directed the disbursement of funds to be done in terms of its previous orders. The court has been hearing the plea by Franklin Templeton challenging a Karnataka High Court's order, which restrained winding up of 6 of its debt schemes without obtaining the consent of its investors by a simple majority. The court observed that for the purpose of winding up mutual fund schemes, the consent of the unit holders stipulated under Regulation 18, Sub-Regulation 15 Clause C of the SEBI Mutual Fund Regulations would mean consent of majority of the unit shareholders who have participated in the poll and not consent of majority of all the unit holders of the scheme. The bench of Justices S. Abdul Nazir and Sanjeev Khanna observed that more clarity and certainty has to be brought in the mutual fund regulations because modern regulatory enactments bear heavily on commercial matters and therefore must be precisely and clearly legislated so as to avoid inconvenience, friction and confusion, which may, in addition, have adverse economic consequences. The Supreme Court has observed that recruitment of candidates in excess of notified vacancies will be violative of Articles 14 and 16 Clause 1 of the Constitution of India. The government of Maharashtra had notified 828 vacancies for promotion to the post of police sub-inspector, and later, by way of a government resolution, it notified a policy decision to accommodate 636 additional candidates who had secured more than 230 marks in the LDCE 2016 examination. This resolution was challenged before the Administrative Tribunal, which ordered status quo and then vacated it. The High Court issued a direction to the state. The Supreme Court has directed that the vacant seats in first-year BDS course for the year 2020-21 shall be filled up from candidates who have participated in the NEET UG courses for the year 2020-21 after lowering the percentile mark by 10 percentile. The bench comprising Justices L. Nageshwar Rao and Krishna Murari observed that lowering the minimum marks and reducing percentile for admission to the first-year BDS course would not amount to lowering the standards of education. The court noted that in 2019, the centre had lowered the qualifying cutoff percentile for NEET UG 2019 for admission to BDS course by 10 percentile for each category. The Supreme Court has ruled that Section 10A of the Insolvency and Bankruptcy Code bars initiation of corporate insolvency resolution process with respect to a default which occurred on or after March 25, 2020, even if the application for CIRP was filed before June 5, 2020, when Section 10A was inserted in the statute book. In this case, an employee had a claim of Rs 104 crores upon his resignation in January 2020. He was requested to continue till April as notice period. He raised a claim when he was in service in March, but 3 days before the date of leaving in April, he was terminated and the amount was not paid. He filed an application under Section 9 of the IBC to recover his due in May 2020. However, in June, Section 10A was inserted into the IBC. The organization submitted that his claim was barred as per Section 10A. This was upheld by the NCLT and the Appellate Tribunal. The bench of Justices D.Y. Chandrachud and M.R. Shah upheld the NCLAT order and clarified that the provisions of Section 10A shall not apply to default committed under the said sections before March 25, 2020. In a significant verdict, the Supreme Court has held that an order refusing to condone the delay in filing an appeal under Section 34 of the Arbitration and Conciliation Act 1996 is appealable under Section 37 of the Act. The appeal arose out of a Delhi High Court judgment wherein it was held that such an appeal was not maintainable. Considering the importance of the question of law, the High Court had granted certificate of appeal to the Supreme Court under Articles 133 and 134A of the Constitution of India. Allowing the appeal, the Supreme Court set aside the impugned judgment of the division bench, and the matter was remitted to a division bench of the High Court of Delhi to decide whether the single judge's refusal to condone delay was correct or not. The Supreme Court has observed that even a blank check leaf would attract presumption under Section 139 of the Negotiable Instruments Act when signatures are admitted by the accused. In this case, the High Court had reversed the order of acquittal passed by the judicial magistrate and convicted the accused under Section 138 after noticing that the accused had admitted his signatures on both the check and the deed of undertaking and had thus acknowledged his liability. Agreeing with the view taken by the High Court, the Apex Court bench observed that the trial court completely overlooked the provisions and failed to appreciate the statutory presumption drawn under Sections 118 and 139 of the Act. In an important verdict, the Supreme Court has held that facility of scribe can be provided for persons with disabilities other than those having benchmark disabilities. The bench, headed by Justice D.Y. Chandrachud, directed the government to frame proper guidelines which would regulate and facilitate the grant of a facility of a scribe to persons with disability within the meaning of Section 2 Clause S of the Rights of Persons with Disabilities Act 2016 after consultation with the public, specifically with persons with disabilities and organizations representing them. The bench also observed that the decision in V. Surendra Mohan versus State of Tamil Nadu would not be a binding precedent after the coming into force of the Rights of Persons with Disabilities Act 2016. In the Surendra Mohan case, a two-judge bench of the Supreme Court had held that stipulating a limit of 50% disability in hearing impairment or visual impairment as a condition to be eligible for the post of judicial officer is a legitimate restriction. The Supreme Court has reiterated that the consumer fora has no jurisdiction and or power to accept the written statement beyond the period of 45 days while relying on its 2002 decision in the case of J.J. Merchant and its subsequent authoritative decision in the Constitution Bench in the case of New India Assurance Company Limited versus Hilly Multipurpose Cold Storage Private Limited, passed in the year 2020. The Supreme Court has quashed criminal proceedings against a man accused of abducting a woman who later married the main accused. A complaint was filed in the year 2013 against Vikram Roop Rai and Vishwas Bhandari for kidnapping a girl under the pretext of marriage. Later, the girl married Vikram Rai, who was acquitted by the trial court on the ground of the girl being a major on the alleged date of occurrence of the abduction. Thereafter, the other accused, Vishwas Bhandari, approached the High Court seeking quashing of the FIR and subsequent proceedings on the ground that there was no allegation against him in respect of the abduction, which was dismissed by the High Court. In appeal, the Supreme Court noted that there was no evidence against the accused and the proceedings initiated against him on the basis of the FIR would be untenable. The Supreme Court, in a case where a bank manager was imposed with a punishment of compulsory retirement, has observed that detailed reasons are not required to be recorded by the disciplinary authority in an order imposing punishment by accepting the findings recorded by the inquiry officer. In this case, the disciplinary authority had accepted the report of the inquiry officer that the manager had disbursed loans without following due procedure and that there were allegations of misappropriation against him. The Guwahati High Court had upheld the compulsory retirement order. The bench, comprising Justices Ashok Bhushan, R. Subhash Reddy and M. R. Shah, observed that punishment was imposed based on the findings recorded in the inquiry report, and as such, no further elaborate reasons were required to be given by the disciplinary authority. Even a trespasser who is in established possession of the property could obtain injunction, the Supreme Court observed, while upholding a Madras High Court judgment decreeing an injunction suit. The bench, comprising Justices Ashok Bhushan, R. Subhash Reddy and M.R. Shah, observed that the principle that plaintiff cannot seek for a bare permanent injunction without seeking a prayer for declaration will not apply when the plaintiff's possession over the property is admitted and established. The court remarked that the matter would be different if the plaintiff himself elaborates in the plaint about title dispute and fails to make a prayer for declaration of title along with injunction relief. The Supreme Court has directed release of a murder-accused farmer who spent 18 years in jail. The case was regarding murder of one Karthik Ram at the hands of the accused in May 2002. The accused had allegedly assaulted the deceased with a spade and hit him with a stone on his head over a dispute regarding construction of a wall. The trial court convicted him under Section 302 of the Indian Penal Code and sentenced him to life imprisonment. His appeal before the High Court was dismissed. The bench, comprising Justices Hemant Gupta and S. Ravindra Bhatt, observed that injuries were inflicted without premeditation in a sudden fight in the heat of passion, and that it was a case falling under Exception 4 of Section 300 IPC. The bench held that the accused was liable to be convicted for the offence under Section 304 Part 1 of the IPC and not under Section 302. A bench of Justices S.K. Kaul, Dinesh Maheshwari and Rishikesh Roy observed that a heart ailment, dilated cardiomyopathy condition, is not covered within the definition of disability in the Rights of Persons with Disabilities Act. In the absence of any connecting link between the job and a medical condition, the disability compensation is not merited, the bench said while dismissing the appeal. Consent of family, community or clan is not necessary once two adult individuals agree to enter into a wedlock, the Supreme Court has observed. In this case, the father of the girl had lodged a missing persons complaint after she had eloped with the boy without informing him. Even after knowing about their whereabouts and the factum of marriage, the investigating officer had insisted that the girl should appear before the police station to record a statement so that the case could be closed. The bench of Justices Sanjay Kishan Kaul and Rishikesh Roy said that the police authorities shall formulate guidelines and training programs about how to handle socially sensitive cases, like those arising out of interfaith and intercaste marriages. The court observed that IO should have conducted himself more responsibly in closing the complaint. The Supreme Court has refused the plea seeking compounding of offences of two police officers accused in a custodial violence case. The police officers were convicted under Section 324 of the IPC, and it was found that they had mercilessly beaten the deceased in the premises of the police station in the year 1985. Considering their age, the sentence was reduced, but the bench, comprising Justices Ashok Bhushan and Ajay Rastogi, enhanced the compensation to Rs 3.5 lakh each, in addition to compensation awarded by the High Court to be paid to the legal heirs of the deceased. The court also observed that grant of leave, as contemplated by Section 320 Clause 5 of the Code of Criminal Procedure, is not automatic, nor does it have to be mechanical on receipt of request by the accused, which may be agreed upon by the victim. The bench noted that the guiding factor for the court to grant or refuse the leave for compounding would be the nature of the offence and its effect on society. That's all. Thank you for joining me today. This is Taniya Pandey for LiveLaw. Have a wonderful day.
Subscribe to our channel and press the bell icon to never miss a video from LiveLaw.